Ho ho feckin' ho, the Irish Demon here, back with another video. And today, next on the naughty list, we have Sarah Jo Fuson. She's the daughter of Montgomery County Sheriff John Fuson, and she was recently convicted and now sentenced for some really horrible things that she did while working in a child daycare center, causing some fairly serious injury. Sorry, my headphones are making weird noises. Causing some pretty serious injury to a child. And yeah, you're going to be blown away here. First and foremost, we have the mother of the child giving her victim impact statement, followed by Miss Fuson's mother herself giving her statement, followed by the defendant. Now, what you're going to be blown away by here is her complete lack of remorse. The woe is me in this lady is quite something considering what she did. Now, following on from that, we will then go back to the judge, and the judge has some seriously sharp words for this lady. And yeah, it's quite something. You're not going to want to miss that. Obviously, you know, you read the title of the video, so you already know what sentence she got. But when you see it actually in action, her being sentenced like that is quite something. So let's have a look at this. Just a heads up, I mean, it's not horrific compared to some of the stuff we see, but it's not very nice either. So, yeah, just be prepared for that. I'm not going to be on the screen the whole time for this because there's no need for me to be. It's not a funny video. It's actually quite horrible, but it's good to see the justice being served. This is in the state of Tennessee. They don't mess around in the South, as you guys know. So let's get stuck in here. And as we're going along, leave me know in the comment section below what you think. Actually, real quick before we do, much like a skydiver with severe IBS, YouTube has been shitting on me from a great height. I had 3 copyright strikes. I beat them all. They were bullshit. And so now my channel's completely clean in that respect. But you still kind of get punished, right? Because I wasn't able to upload. There's this, you have to rebuild the trust thing or whatever. And it's taken a while. It's been kind of rough. I have gotten messages from people suggesting that they've been getting notifications again. Let me know in the comment section down below. How did you come across this video? Did you see it on your homepage? Did you get notified of it? Did somebody tell you about it? You know, did you have a dream in the middle of the night that told you to go looking for my handsome, slightly yellow face because of this light? Just let me know. I would really, really appreciate it. Make sure and hit the thumbs up button, share, consider leaving a super thanks or a PayPal or what's the new thing? A hype. I don't know what that is. Apparently it's good. Hype the shit out of it. I don't know. Anyway, let's go and have a listen to this. As I say, I won't be on screen for this part of it. I'll pop in and out as need be.
Good morning, ma'am.
Good morning.
Could you please state and spell your name?
Macy Hyde, Macyhyde.
You're the mother of Olivia. And have you prepared a victim impact statement today that you'd like to read?
Yes, sir.
With your court's permission, I would ask her to read.
Lord.
Your Honor, my name is Macy Hyde, and I am the mother of Olivia, the child who has been deeply harmed in this case. There are no words to describe what it feels like to realize your baby has been harmed by the very person you trusted to care for her. When I first saw the bruises on Olivia's little arms, I felt a mix of confusion, fear, and indescribable pain. I had trusted Sarah with the most precious thing in my life, my daughter, and that trust was shattered. I am here today to share the profound and lasting impact the defendant's actions have had on my daughter, on our family, and on me as her mother. Since the abuse, our lives have been consumed by emotional turmoil, fear, and uncertainty. Olivia, though too young to fully understand what has happened, continues to suffer the effects. For months after the incident, she woke up screaming in the night. She had panic attacks and was showing an overwhelming fear of sleep. Putting her down at naps and bedtime became an emotionally charged ordeal. Even a year after the abuse, she still exhibited signs of trauma. We had to seek play therapy because she refused to let us touch the backs of her arms. And she displayed concerning behaviors during play, acting out as a student or a teacher, which hinted at her distress. A simple touch in the wrong place could trigger a meltdown, with Olivia begging us not to touch her that way, as if she was reliving the horrors. As a mother, the emotional turmoil has been unbearable. Every day, I live with the constant anxiety that my children may be hurt again, fear that grips me every time I drop them off at school or leave them with anybody other than myself. Things that once felt routine, like school drop-offs, babysitters, and playdates, are now moments of intense dread and second guessing. I regret deeply that I took Olivia back to Sarah the day after the abuse. The guilt that haunts me for that decision weighs heavily on my heart, and I still to this day struggle to forgive myself. After watching the trial videos, my husband and I experienced nightmares, uncontrollable tears, and unable to shake the images from our minds. We both sought therapy to cope with the trauma, including EMDR, to help erase the haunting memories. Rewatching the footage in October just reopened old wounds, bringing back intense pain and the memories of that time. Our daily life has been irrevocably changed. My children have become more cautious, and I have become hypervigilant. Every change in behavior raises a red flag in my mind. The fear I now carry is not a life that I ever imagined for my children. Yet it is our new reality. This summer, I struggled to send our son to daycare after we moved. The anxiety becomes so overwhelming for me that I almost pulled him out after just 3 days of being there, fearing the worst from what had happened to Olivia. Thankfully, Olivia is now in a school environment with teachers whom I trust, but the fear remains. I still scrutinize every detail of her day. I overanalyze every situation, and I am constantly on alert for any signs of distress, whether it's just a bruise or a change in behavior. The trust we once had in the world around us is shattered. Sending my children to school or leaving them in the care of others now feels like a risk that I cannot fully bear. The ripple effects of this trauma has permeated every part of our lives. I am deeply concerned about the long-term emotional scars that she may carry. I wonder how this experience will shape her sense of safety, her relationships, and her future. No parent should have to question whether their child will carry lasting pain from something that they never should have had to endure. I also understand that the fear and the anxiety that I live with will not disappear overnight. This trauma has fundamentally altered me, both as a mother and as an individual, and I am no longer the person I was before the abuse. I am forever changed. Your Honor, I ask the court to remember that behind this case is a real child, a baby who was frightened, abused, and betrayed. I ask the court to fully understand the deep, lasting harm that this has caused to Olivia and our family. She deserved to feel safe. She deserved to be protected. Instead, she was harmed in a way that no child should ever be harmed. The consequences of this abuse will affect us for far longer than this legal process. I thank you for allowing me the opportunity to share the impact this trauma has had on our lives, and I hope the court's decision reflects the gravity of the suffering and the fear that my family continues to endure. Thank you.
Thank you. We'll mark that as an exhibit next in order, which would be 2.
So that's the mom's testimony there, or her, I suppose, victim impact statement. I'm just going to skip on to the next one, and I think the next one is so the next up is the defendant's mother. So have a listen to this. Tell me what you think, because obviously the mother giving her victim impact statement, the mother of the child, the purpose of that is to, number one, to tell the court, this is the effect that this has had on the child and us. But also, in a lot of these cases, you'll find, a lot of people say things like, Your Honor, I'm a Christian, I believe in forgiveness, and I will forgive this person, but they do need to feel, whatever for what they've done, which I'm totally in favor of. I think forgiveness is very important. Sorry, I just need to fucking move this. Anyway, it's easy for any of us, I think, to say about forgiveness that, X, Y, and Z person should be forgiven to an extent while still, feeling the consequences of their actions. But when it comes to kids, be it this kind of thing or the other kind of horrible stuff that happens, it's very hard, I would suggest, to consider forgiving somebody in that scenario. I adore children. I think children are just the most wonderful thing in the world. And I can't wait to be a daddy myself one day. Don't get me wrong. I love them. I think there's something so special about them. The thing is, for a human child, right? We're somewhat unique in the animal kingdom, and any parent out there will know this. A human child needs its parents and the adults in its life to protect them and guide them and to teach them and to feed them, even especially in those first, years, those first 2 or 3 years, because they can't do it for themselves. And it requires an immense amount of trust, which is naturally inherent in a child, to be able to survive, essentially. And the breakdown in trust here is massive, because any child who's in a daycare center, let's say they're there for, I don't know, I guess an average of maybe 6 to 8 hours, maybe longer, depending on, a parent's work schedule or whatever. It takes a huge amount of trust for that child to be able to be comfortable and happy and to learn and thrive in that environment, because, there's so many different adults. And I guess, again, inherent in us as our species is, inherent in us as a species is that need for a tribe, right? They say it takes a village to raise a child, and that's true. I saw that with my own brothers with their kids. Like they needed help from me at some point. Like, there's some things that maybe my niece or nephew would want to talk to me about instead of their mom or dad, or whatever the case may be. There's trust in that, and that's vital that trust is held. So for this child to go into an environment at such a very, very young age and to be incredibly vulnerable at that age and to be treated the way she was is horrifying. Now, I didn't see the CCTV footage in its entirety. I did see some stills from it. It was during nap time. So I'm guessing, again, this child is probably there for quite a long time throughout those days that she's there. So these are the adults in her life. These are the parents, to an extent, not parents, but kind of surrogates, I suppose, for a young child, because that's how they understand the world. And it's quite scary to see, because, and I mean no disrespect to the defendant. Well, I mean, I don't really care, but she's a larger lady. For anybody out there who's into horse racing, let's just say she wouldn't go well on soft ground. So she's a big woman, she's an imposing figure, and you have this tiny, tiny little child on a nap mat on the floor, and she keeps bouncing the kid, not bouncing her, but throwing the kid down and hurting her and stuff like that. And this child is tiny. It's a baby. Come on. Don't get me wrong. We've all been there where, you're on an airplane or in a train or something, and there's a screaming kid behind you and you wish you could go back in time and hand that person a condom, but that's life. You just get on with it. I was a kid once too. I screamed like that until I was 27, 28. You know what I mean? It just makes me so mad when people hurt kids, because it just drives me insane. But anyway, so what I want you to keep an eye on here, think about how the defendant's mother acts here and the things she says, and whether or not you think that maybe they think it's as serious as it is, because obviously this is incredibly serious. This child had a fractured skull. She could have been killed in this scenario, a little baby. But listen to the mother. Now, bear in mind as well, this is the defendant's mom, right? So she's also trying to protect her child in a way. So anyway, yeah, let's go back to it. Sorry for that long thing. It's something I'm passionate about, and I as I say, I adore kids, and anybody who harms a child to me is dirt. So yeah, let's go back here. All right, here we go.
Good morning, Mrs. Fuson.
Good morning.
State your name for the court, please.
My name's Jennifer Fuson.
And you are the mother of Sarah Fuson, is that right?
I'm Sarah's mom, yes.
And where do you live?
I live in Woodlawn, Tennessee. I've lived there my entire life.
And how are you employed?
I'm a school teacher, elementary school teacher.
How long have you been a school teacher?
And this is year 28.
Describe your relationship with your daughter, Sarah.
When Sarah was born, she was the biggest gift in our life. We just enjoyed, she was the sweetest child. She gained the nickname Sweet Sarah. everything about raising her was a joy to me. Was actively involved in so many activities and so many things. We were actively involved in our church, and one of the greatest blessings was she was baptized at age 7. And that gives me lots of comfort.
If you would describe for the judge the impact that this prosecution and trial has had on Sarah.
The impact it has had on Sarah is great. From the beginning, there was an immense amount of media and social media coverage because of who her father is. This caused extreme embarrassment and shame. I knew that that day, January the 10th, when I came home from work and heard what Sarah's account, that very confident, independent girl that we knew and raised was gone. As time went on, she felt that life had no meaning and like she had a gorilla on her back. She attempted suicide. We committed her to a mental hospital for a couple of weeks. She came home on lots of mind-altering medications. The medications would change off and on. In the process, she's gained about 50 pounds. When we got her kind of back a little bit mentally stable, trying to get a new job was very embarrassing, to say the least. She would attempt one after another. With the charges on her record, it would come back when they did a background check. So she would get fired. And some of those firings were very, very humiliating. During this period, I made sure Sarah was with me or someone at all times. I did not feel safe leaving her by herself. Everything is worrisome and extremely painful. Finally, she landed a job. She made friends, and she started thriving. But we knew this trial was looming over us, and we were not going to get through this unscathed. Her anxiety was eating her up. The girl that you saw in court during the trial was ridden with anxiety and was not the same girl that I raised. It's the amount of pain all of this has caused has been a very heavy burden to live with and to carry, and we will continue to live with and carry this.
Is there anything that you would like to say to the Hyde family?
Yes, I would. I've wanted to speak with them from the very, very beginning. I am so sorry for all of your pain and all of the trauma and all of the mistrust in society that this has caused you. I've tried. I wanted to from the very beginning to reach out. I was advised not to. I even wrote you all a letter. And I know it wasn't given to you. We do not, as a family, condone what Sarah did that day. We don't, but we do love our daughter. And just as anything your children do in life, you try your best to raise them and support them and get them through the hard things in life. I do know that Sarah did not go to work on January the 9th, 2023, thinking she was going to harm a child. Also know that Sarah did not think her actions at the time were hurtful. It was only when she saw herself on video that she thought, yeah, that was rough. Sarah was raised in a home of public servants. She only wanted to serve others. She reverted that day back to the daycare training at nap time. She should have never, ever, and no one should ever work in a daycare where you are enclosed in a room with lots of children by yourself. Daycare system needs a big overhaul. Lots of training, lots of supervision. And there should always be more than one adult in a class.
Hold on a second,
regardless of
right?
the
I get it, right? That I would imagine it is difficult to work in a daycare center anyway. In fact, I know people who have, and you see them after work and they're just like, oh, because all it takes is one kid to be in a bad mood, and then all the kids are in a bad mood. You know what I mean? That's the way it goes. Like even today, I was chatting to an old friend of mine, and like she was sending a what you call it, like a video. We were having a video, not a video chat, like as in anyway, basically sending each other just video chats. And she's got three of the most adorable little kids, right? And they are so sweet, lovely children. But one of them was not in good form. She was quite unwell. And then the other two were also screaming. And like she was just showing me like this is what it's actually really like. So she's driving along and these three kids are screaming the roof off the car. That happens. The fact of the matter is, this is what, maybe 40 something year old lady, 30 something year old lady. I'm not 100% sure. And if you're in a daycare center and all of these kids are going nuts, right? Even if it's 100 of them and one of you, that doesn't justify what she did. You know, like I won't necessarily go into great detail about it. It's not like in terms of child abuse cases that we've all seen on these kind of shows, it's not the worst of the worst by any stretch, but it's really bad, like really, really bad. It's not justifiable. If need be, you just have to call in other staff or go to the owner, the management, and be like, this is too much for me. Rather you get reprimanded or lose your job for not being able to handle all those kids. And it may well be the case that, yes, there needs to be more staff. That's a big problem here in Ireland with respite centres for children in particular with disabilities, but also for elderly care, where staff are just stretched thin. When I was in hospital, even in ICU, and I would be hitting the button looking for a nurse because I don't know, I coughed strange and hurt myself even more and couldn't move. It took ages for nurses to get there. We don't have enough of them, but the nurse didn't beat the shit out of me because of it. That's not how that works. Also, I got a big email the other day. Somebody said that I was lying about my injuries. And I was like, yeah, I fucking wish I was. I wish I was. I still, like, I'm recovered like 70%, I would say, would be the best way I could describe it. My ankle's doing much, much better. I don't need a crutch or a cane or anything anymore. It gets sore as the day goes by. I was out there chopping wood today. So yeah, I'm going to wake up. My ribs are going to be sore as hell and my ankle's probably going to be sore, but I'm doing so much better anyway. And thank you, lads. I can't. What in the name of Jesus? My phone just started playing a video by itself. But a massive thank you guys to everybody who reached out and the lovely messages and stuff. And I do apologize for not getting back to people. When I was in hospital, I didn't know what was going on around me. Basically, I was on huge amounts of painkillers. They put me on ketamine. It was actually kind of funny. I'll just tell this little aside real quick, skip through if you're not interested. When I got into the ICU, doctor came over, dude looked like a homeless hippie. And he was like, hey man, have you ever had ketamine before? And I was like, no, I actually genuinely hadn't. And he's like, well, look, you're about to, and it can get a bit gnarly. So think happy thoughts. And then they gave me the ketamine. Jesus, Murphy, I was higher than the Sputnik. I had no idea what was going on. They had to have two nurses sitting beside me when I was coming around to like hold my arms in place because I kept trying to stand up. And yeah, I can show you guys some gnarly pictures from when I was in hospital. I don't know if you can see it here, but like a piece of my motorbike went through my leg. Like the front of it went in and out the other side of my shin. The ankle break wasn't actually that bad. In fact, I didn't even really notice. The worst part about it was how uncomfortable the cast was. But it broke in an area that is kind of the better place to break an ankle, if you could say that, because it heals better than if it was up higher or down lower or whatever. So that's doing all right. The ribs, that was a bitch. Some guy said, oh, there's no way that he could have had a collapsed lung and a punctured lung. I absolutely fucking did. Slight puncture in the bottom of this one, hurt like a motherfucker, took ages to heal. And this one collapsed on impact, and it reinflated, obviously, because I'm here talking to you. But yeah, a lot of medical experts out there. But fuck those guys, basically. I went through a lot of pain. I lay on that couch right there on this side for, what, 2 months? 3 months maybe, without moving. I had to go in and out of hospital. I kept getting infections and shit. It was brutal. It was the worst 4 months of my life. And there was a lot of other crazy shit happened outside of that. So yeah, fuck those guys. Thank you for those of you who reached out and sent your regards and everything. It meant a lot to me. Like, I know people say it, oh, it means so much. Literally just meant so much, guys. I really do appreciate all those lovely emails. Anyway, I'm sorry, that was a huge detachment from what we were supposed to be talking about here. But back to the video. Let's see what Mammy has to say.
Regardless of the number of children in that room, regardless of everything that you guys have been through and what we have been through, Sarah is not a throwaway person. She is kind. She is generous. She is loving. As her family, we need her. We depend on her. And we will have a big hole at our table and in our hearts until she is returned home to us.
Thank you. Those are my questions.
Thank you, ma'am. You may step down.
I feel like my big monologue could have waited about 20 seconds there. Right, I'll skip through to the next part. Next up is the lady herself, the defendant in this case. Right, sorry now for ADD and out there. I haven't had a chance to like the last few videos that I made are doing pretty well, which is great. It means, I guess, the algorithm is kind of in my favor again, which is, it's about fucking time. But obviously this kind of thing I'm passionate about, but also just, with respect to my unfortunate situation with my bike crash and stuff like that. I just really wanted to thank you guys for your support. People, I saw some horrible shit too, don't get me wrong. I got some absolutely disgusting emails from people wishing, well, two in particular, wishing that I didn't make it, this kind of thing. Like, it was that bad, right? That the whole road where it happened was shut down. It's only like 2 minutes from here. The whole road was shut down for about 3 or 4 hours until the Gardaí, which is the Irish police force, got the nod from the hospital to say that they thought, he's going to make it now. They had to preserve it just in case. Like, that's serious. That it was that serious. I got through it okay. With a lot of support from everybody. Everybody's just awesome, and I really do appreciate it. But yeah, even when I was in hospital, I did do one live stream where I was absolutely off my chops. And I don't get high, so I'm not used to it. But I remember getting emails and stuff after that, and seeing people comment on it saying things like, "Oh, here comes the grift" or whatever. I didn't ask for a bean from anybody. I haven't made anything from YouTube in like 4 months. I've been concentrating on getting fit and healthy and getting my life back in order. And it's been going great. It's been going really good. And I'm really happy to be back here doing YouTube again. Like, it's awesome. Anyway, let's have a listen to this absolute piece of shit. I mean, the defendant here in this case, Sarah Jo Fuson. And now listen to the lack of remorse here, right? And the woe is me.
You don't
and
have to be sworn. This
keep
is
an eye on the judge's face, right, as she's talking. I love Judge Wolf. I think he's fantastic. He's a true no-nonsense judge, right? He just sees it and says it as it is. And you'll see how he reacts to her lack of remorse here in just a minute.
An allocution which you're allowed to make a statement without having to be placed under oath. So,
Good morning. Go forward with your statement.
I want to start by apologizing to Ms. James, the probation officer, about my comments about the case. I was still adjusting to jail and was going through a difficult time. That's not how I feel about the case. I never intended to hurt Olivia. I had been working at Tylertown for 6 months when this happened. I loved my job, I loved the children, and I got along very well with the staff. I used to look forward to going to work every day, to be with those children and be in the environment. I was always alone with 6 children in my classroom. Sometimes it was difficult to give one child the attention they needed when I had 5 others to care for. I find myself hurrying and multitasking all the time. It was also hard to give the new children the attention they needed to transition into the toddler room. I didn't realize I was being rough with Olivia in the moment. I recognized that I was rough with her and regret my conduct. To Olivia and her parents, I am so very sorry that this happened and what this has put your family through and the trauma that Olivia had to go through. If I could go back and make this right, I would have been calm and gentle as usually I was and not rough. I love children and animals, and it is not in my nature to be rough. I hope someday that Olivia and her family can forgive me and we can move past this. I want to thank my parents and my family for supporting me and standing by me through this very difficult process.
Thank you.
Thank you, ma'am. You may step down.
All right, short and sweet. Now, straight off the rip there, I'm just hearing, all I'm hearing there is, I don't think I did anything too bad. It's the daycare's fault because there was, too many babies and not enough non-abusive staff. That's it, really. This has affected me and my family and my life. Yeah. Because of what you've done. Like, I would absolutely never even remotely think about taking this out on her family. They didn't do this. If anything, I would feel bad for her family having to put up with this shit. And yeah, like that's basically it. Yeah, okay, maybe a brief non-apology, but that's it. That's not enough. This is somebody's baby you're fucking after hurting here. All sweet and lovely here, right? I didn't mean it. I don't think I did anything wrong. But I have remorse. No, you fucking don't. But now we're going to hear some of the stuff that she was saying off the record, in jail and all that kind of thing. The judge is going to lay this out. He's going to long dick this whole thing. Here we go. Oh yeah, so closing arguments here. Well, not closing arguments, but arguments in mitigation and stuff coming up. The lawyer's attitude here, I'm not a fan of, but he's just doing what he's got to do, doing his job.
Just as it relates to enhancement factor 4 that the state included in its memorandum, see the response from Ms. Fuson that we received yesterday. We think the language in the Adams court is clear. The court states that the vulnerability enhancement relates more to the natural, physical, and mental limitations of the victim than merely to the victim's age. And the state submits that in this case, we're dealing with a 13-month-old victim that did not have the ability to resist in any way. She didn't have the ability to tell someone and ask for help, nor did she have the ability to testify as to what occurred at a later date, which is what the language that is cited in the Walton case as well, that the state included in its memorandum. As far as enhancement factor 14, we think the language in that is clear. It says position of trust or a professional license. We submit that Ms. Fuson was in a position of trust, no greater trust than caring for that of someone else's children. We submit that enhancement factor 14 does apply in this case. And the same with enhancement factor 15. We think the wording of that is clear as well. States that this occurred on the grounds of a pre-kindergarten through grade 12 while children were present. The proof showed that this occurred on the grounds of a pre-kindergarten while children were present. It doesn't mention anything about it has to be an attack on the school itself. It just says while they're present. That's what occurred in this case. We think all three enhancement factors apply, and we'd ask that Your Honor include those in your consideration. Thank you.
Raymond?
Good morning, Your Honor.
Good morning.
Be a little longer. Sentencing spread for Class A felony. And I know there's another count, but we're here to talk about the Class A felony. That's the sentencing spread is 15 to 25 years. Under recent amendments to the law that apply in this case, it is 100%. There's no parole. There are no credits served every day. My position is pretty simple. The government's pleadings say they want a sentence more than 15 years. They haven't said what number they want, but they want it more. I think that a sentence of more than 15 years is brutal, unnecessary, and consistent with the sentencing law. I want to think about 15 years for a minute. I think everybody on this side of the table went to college, most of us. That's 4 years. 15-year sentence is 4 times of being in college. When you put it in real terms of spending time, it's forever. The college was an education, and for most of it, it was having a good time. Being in prison for 15 years is being locked up in a cage. I was at the penitentiary at the women's prison 4 days ago, parole hearing. There's barbed wire everywhere, it's silent as a tomb. You don't throw sentences around like candy anymore. There's no such thing as a mid-range sentence to make everybody happy at one end or happy at the other end. We are talking about real years here. State sentencing memorandum focuses on the aggravating factors, which I'll address in a moment. But there are other important parts to the sentencing statute. It's no secret that I served on the Sentencing Commission and was vice chair of the Sentencing Commission for years. Sentencing Commission was necessary because our statutes were in horrible disarray. Sentences were completely out of whack, and we wanted to bring some order to things. So let's talk about the vulnerability of the victim. It is an element of the crime. The element of the crime was enacted as Haley's Law back in 2025 when they enhanced it by children under 8 who suffer severe abuse. That's the point of it. To say that this child was severely injured or whatever is an element of the crime. There's no other way to talk about it because they had to prove severe injury. They had to prove that the child was under 8. This is the same exact thing. And if it does apply, it is so close to an element of defense, it runs the risk of double counting. So I suggest that factor's off the table. Now, the next factor is that this happened in a place where there's children. It duplicates the position of trust factor. She had to be there if she's in a position of trust to be a daycare operator. She had to be there for this thing to have even occurred. That particular enhancement factor is designed specifically, we read it with common sense, of people that go to schools and have school shootings and harm the school as an entity. That's the whole point of it. It's an absolutely appropriate enhancement factor. Totally, because of some person shows up at a school and starts shooting the place up or committing violence in a school where there's kids and stuff, of course that needs to apply. That's not what happened here. The aggravating factor needs to be read with a dose of common sense. That's the whole point of it. That's why it's there. And it duplicates the position of trust factor. So I suggest that's off the table. It's just not applicable here. And if it is, it's de minimis because it's not what it's designed for. And then we talk about the position of trust. She was not licensed. She was in a position of care of these children. And yes, so I suggest that that enhancement factor may apply to some degree because she had care of the children. I was not unmoved by the mother's testimony at what happened to her child, that she put her child in the care of the daycare and my client. So is there a position of trust there? To some degree, there is. I don't want to be disingenuous and say that it's an irrelevancy. Of course it is. But I suggest that it duplicates the other factors to where they don't apply, so we're just dealing with the one situation. But think about this offense could not have occurred unless she was in that particular position. So it's duplicative. Now, let's talk about the mitigation, which we have to consider because you consider the aggravating factors and the mitigating factors. The mitigating factors are abundant. My client, I don't think had ever been arrested in her life. No prior record at all. This event occurred on one occasion, and not like the many child abuse cases that Your Honor sees where it goes on for weeks and months and years. It's an isolated event. So those are mitigating factors there. The fact that she tried to commit suicide, the fact that she was despondent over what she had done is huge mitigation in the case and detracts from whatever abuse there exists. And so I suggest that when you consider all this mitigation involved in the case, that 15 years is the appropriate sentence. Now, there are other factors that the court would want to consider. When the statutes were enacted, they were 30%, 35% for range one offenders, which she is. The sentencing grid was designed for parole. That's the way it was. So when you have a sentence of Class A of 15 to 25 years and there's a 30% parole, the courts would consider parole as part of it. Even if you gave the minimum of 15, then the person would be eligible after 5. But now the sentences are at 100%. The sentencing mindset that we had 5 years ago isn't applicable today. Our sentences have gotten inflated, but there's no change in the sentencing lengths. It doesn't work the other way, unfortunately, when the sentences are at 100%. So we don't have to talk about the fantasy that we engaged in where you say, well, you give somebody 9 years and maybe they'll be out in 3 and maybe they won't. So maybe we can adjust the sentence accordingly. This is real time. It's just like the federal government. When Mr. Strines and I go to federal court, it's 100% over there too. But the federal government had some common sense, if you can believe that. They reduced the sentence lengths to account for doing away with parole. And we engaged in utter madness in our state, where we left the grids the way they were and went up there. This is not the time or place for me to complain about that. We'll pay the price for that one day. And there'll have to be another sentencing commission to undo all this mischief. But the problem is, Your Honor is imposing a sentence today that's 100%. That will not change. We incarcerate more women in this country than any other country in the world. with the exception of some Middle Eastern countries, would actually kill women. The purposes of the sentencing and the guidelines must be considered. Your Honor knows that. The court's going to articulate that. Let's talk about that. The sentence says under 102 must be imposed that is justly deserved in relationship to the seriousness of the offense. Justly deserved. Why in the world does this girl need more than 15 years at 100%? The law also requires elimination of unjustified. Punishment must consider restraining defendants with a lengthy history of criminal conduct. That we're not have that here. Ms. Fuson does not have any prior history. Next, the court has to consider whether other measures less restrictive than confinement have been applied unsuccessfully. She'd been on probation 5 times, violated them. Of course the court would consider that. So we've tried everything we can. Your Honor does that every day. That's not what we have here. And most importantly, the sentencing principle says the sentence imposed should be no greater than that deserved for the offense committed. That's the so-called parsimony provision, the least possible sanction. No greater than that deserved. We have to balance everything. Why in the world should this woman deserve more than 15 years in hard labor in prison? In 15 years, Your Honor, nobody's going to care or know.
Are we now having inmates perform hard labor like chain gangs in the prison system
No, they
that I'm
don't,
unaware
but that's
of?
what the statute seemed they get. The statute said you got to give them a Bible, that they're supposed, they have these archaic.
I just didn't know when you mentioned 15 years at hard labor that was actually an accurate representation of our prison
No,
system.
not any, well,
I understand it's an eloquent reference to other images that we create by putting people in prison, but go ahead, I'm sorry.
Your Honor, I don't want to go too far afield, but I have had constant calls of prisoners being subject to abuse and killed in prison.
I understand that prison is not a pleasant experience.
It's, without using profanity in the court, it's heck on earth. It's a terrible place. It may not be hard labor per se, but it's a hard life. People are extorted like crazy over there. Anyway, but I mean, the original statute says you got to give them a Bible and you're supposed to do all that, but it's not a good place. It's a terrible place. So I suggest the least severe measure is 15 years. Now, I want to talk about the offense a little bit. I wasn't here for the trial. The offense is aggravated child abuse. It's the one offense that's required to commit knowingly. Now, knowingly, we know what knowingly means for murder. We know what knowingly means for most offenses. I mean, you have to intend the result. Child abuse can be committed effectively in a reckless mens rea because it's objective and subjective. You're aware that you're hurting the child, or you should be. That's the definition of knowingly. We have a separate definition of knowingly for child abuse. So if she said, I did not knowingly intend to harm this child, that's true, but she did nevertheless. But she was acting in a reckless way because the statute said should have known. And should she have known that she was harming this child? I suppose so. But I suggest this is much different than the child abuse cases that Your Honor sees, where the child is being shaken all right to the point of death. And they know what's happening, and they intend to harm the child that she didn't intend to harm. I suggest that should be weighed in the balance as well. It doesn't diminish the pain that the parents feel, but it's not the intentional crime. Now, let's talk about 4035-210. It says that the minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum sentence for each felony class to reflect the relative seriousness of each criminal offense of classification. That's what it says. The minimum sentence should be. Is child abuse, aggravated child abuse, serious? Absolutely. But the statute puts it 15 years for that because it's serious. But that's what the statute says. And then you weigh the aggravating and mitigating factors. But I suggest that this is not that complicated. That's what the statute says. It's the minimum sentence. That's what the legislature said. Then you have to consider how long a defendant's going to serve before becoming eligible for release. 4035 says the court must place on the record the estimated number of years and months the defendant will serve before becoming eligible for parole. It's truth in sentencing. So when you impose a sentence, you say, well, everybody, we think she'll be eligible for parole after 30% or 40%. You have to consider that and tell everyone it's 100%. The court should consider that as well. And then you have to consider the evidence on the pre-sentence report and the strong R. What is a strong R? It is a risk assessment. This risk assessment is low. That is a factor the court's required to consider by, is she a threat? No, she'll never work in a daycare center ever again in her life. She'll never be near children in the rest of her life. Impossible. Her risk is low. Is that a mitigating factor? Of course. If it was high, the state would be up here saying and waving it around. They're not. This is not an issue of how tough we can be or what it looks like or making one side happy. Let's look at the person as an individual and ask what is deserved. Locking this woman up in a cage for more than 15 years, I suggest, the state suggests, their position is unconscionable, inconsistent with notions of mercy. And please do not think that the government will come back up here and say, well, what's another daycare worker going to say? Oh, I can abuse this child all I want because I'll just get the minimum sentence of 15 years at 100%. That's not, they're not going to say that. The deterrent effect of imposing sentences diminishes to insignificance after 5 years. Any sentence of more than 5 years, except for maybe for murder, the deterrent effect doesn't have any more effect than that. The numbers become unreasonable, have no added deterrent effect. So why say 16, 17, 20 years that we're going to deter this sort of behavior? 15 years will deter any human. For all those reasons, I'd ask, this person here is a human being. These laws were designed to reflect a sentence for her. The indictment is the state of Tennessee versus her. And the court is the arbiter of what that sentence should be. That's why we have judges. Sentencing guidelines are advisory, but at the end of the day, it's a very human experience. 15 years at 100%. I never thought I would stand in a courtroom in this state and say that such a thing. That's where we are today. No sentence more than 15 years is deserved and would be inconsistent with the rest of the guidelines. And I thank you, Your Honor.
All right. So, you know,
Holder?
I think the lawyer did everything he's meant to do there, right? So trying to mitigate, accepting that it was a terrible thing that she did. And then he goes on to talk about mandatory minimum sentences. And I actually share a lot of the same view, maybe in different circumstances, but I share a lot of the same view as the defense attorney here in this one. I am very strongly against mandatory minimum sentences. The reason being is, you know, with anything in life, there's nuance, okay? Like there's different reasons why certain things happen. So I'll give a very clear example. When I was working in the courts in Western Australia, there was a young lad, an islander boy. He was about 18 years old, big fucking massive Samoan dude, half Samoan, half Maori, I think. So a huge guy. And nothing short of a gentleman, this lad was. An absolute gentleman. And by the time he got there to be sentenced, and I remember the judge very well, he was a very nice fella, great fun, comes to Ireland quite a bit actually, and we drank whiskey together in Dublin not so long ago, just around the start of the summer. But this particular judge, he even said the same thing. He was like, I am so disheartened that I have to give you a minimum of 1 year. And it was for assault public officer. The reasoning behind it was simply that there was a lot of assaults on police officers, right? Like punches and kicks and whatever else, right? But what ended up happening in Western Australia was that, and now I'm not going to say that the cops are corrupt in Western Australia. However, there is a culture of prosecution there, from the public prosecutors, but also from the police prosecutors. And in essence, what I saw from the inside was that they would try to achieve, rather than fairness, just getting the maximum that they could get on somebody. And I don't know what the merit in that was in terms of, you know, does it help their career or whatever the case may be. And this particular lad, he was out on a night out. Cop, he got in a scuffle, I think, in a nightclub, essentially. And a copper grabbed him from behind. And the argument was that he did not know that it was a police officer when he swung his elbow back like that. Now, he didn't injure the police officer. And in fairness to the police officer, he gave evidence. He was like, Your Honor, you know, I wasn't really injured. I got a shock. I got, you know, he hit me in the shoulder. So it's not like he hit me in the face or anything. He was belligerent after it, but he didn't intentionally go out to hit a cop. But it was still assault public officer that he was charged with, and he pled guilty. And as a result, he had to go to jail for a year. He was 21 years of age when he went in to be sentenced. I think it was. Was he 20? No, maybe 20, maybe just turning 20. Yeah, it was about nearly 2 years after the incident or something. And he was so respectful, just a good person, a genuinely good person who was on a night out, got a bit too drunk, didn't realize it was a cop, hit the guy. And I remember his lawyer saying, like, Your Honor, if we had taken this to trial, if I had been his lawyer at the time, he'd gone with a public prosecutor, a public defender that told him to plead guilty, whatever. And I remember his lawyer saying, Your Honor, you know full well, if we took this to trial and it could be proven, you know, based on the CCTV or whatever, that there's no way he could have known it was a police officer, it's likely that he wouldn't have been done for it. It might have got done for like public affray or something. And this lad had to be locked up for a year, and the judge was fucking fizzing. Now, I don't know why he couldn't retract his plea, or if he could have. I'm not really sure, to be quite honest with you. So yeah, mandatory minimums, I'm against. In this case, it's a tough one, right? Okay, yes, and I'm not even for 1 second downplaying the abuse here, right? This will scar this child, and I hope, because of her age, that maybe she'll be able to get past all of that and live a normal, happy life as any child should and deserves to. And the same for her family. Definitely jail time is warranted, right? For sure. The fact that she doesn't show remorse is something that I would say, okay, more jail time is needed then. Have a good feckin' think about it for the next 25 years, as you're going to see here in a minute. Is 25 years, and this is the question for all of you, I want you to just come out of mammy daddy mode, come out of, you know, loving kids mode. Is 25 years a little bit extreme for what she did? It wasn't just one incident though. This was over a period of time she had injured this child, and who knows how many others. I think 25 years, it is a very long time. Okay. It's about what you get for murder, generally speaking. Is it too long? Is it unfair? Is it a bit over the top? I mean, you could argue that it is, because the type of abuse, I suppose, in some respects, isn't as bad as some of the other stuff we've all seen on here. But you also have to weigh up the physical scars versus the emotional scars, right? This is a child who now is going to have severe trust issues with very good reason, because an adult who was put in a position of trust injured her at her most vulnerable as essentially a baby, where you need an adult to do the most basic things for you. Is 25 years warranted? That's the big question that I have for you all here. For me, I think it seems like a huge amount of time Like, it's a quarter of a century being locked away for something without the chance of parole. That's where the problem lies. It's the 100% thing. It's not the fact that she's been now, given 25 years. It's the fact that if she goes and gets counseling and really, really changes her life and changes the way she is as a person in, say, 10 years' time, should she be allowed to attempt to get back into society at that point? I would say yes, personally. Now, if you completely think that's stupid, don't be mean about it. Just tell me, you know what? I disagree because X, Y, and Z. I would love to hear your reasoning. Because I'm not 100% fully formed in my reasoning on it. But that's the way I kind of see it. 25 years as a benchmark. This is how long you're going to fucking stay there. But we'll have a look at it in 5 years. We'll have a look at it in 10 years. See if you've changed your ways. If you genuinely have changed who you are as a person, then perhaps that's a time for release. I just feel like that option should always be there to an extent. Depends on the type of offense, right? If it was the other kind of child abuse offense that we all know and hate, that to me, old school, up against a wall, bang. Like that's, you know what I'm saying? But that's just me. I'm sure most people genuinely do agree with that. Anyway, let's hear what the judge has to say on this one.
Moore?
With all due respect to counsel, I've been around for a long time, and I've heard this before, and perhaps it should be addressed to the legislature, but that's not where we are here today. Your Honor, presided over this trial, you've heard all of the evidence, read the pre-sentence report, considered the statements and testimony here today, and on behalf of the state of Tennessee, I would submit that, yes, at this point in our history, the legislature, for some crimes, has decided that, yes, a person must do real time for a real crime. And this was a real crime whose effects will last far beyond 15 to 25 years. The state submits that the enhancement factors that we argued, that General Holder argued, are present. Case law, yes, it's under 8, it's not double counting, because a 6-year-old or a 7-year-old could come in and testify about what happened to them. That's the entire reasoning for the State v. Adams and the cases that follow, and that's been for 20, 30 years, at least. Happened on a pre-K, there's no dispute about that. Not that, oh, this enhancement factor applies if it is on the grounds of a pre-K and committed by someone who has a firearm or someone who is shooting or killing. No. Legislature could have done that, and they may well do that. They've added enhancement considerations before, but that's not what this one says. And obviously this was conceded where Ms. Fuson, that child was placed into her care, custody, and trust. She betrayed that trust, as we have seen time and time again. The arguments for sympathy and mercy in this case, I submit, are not and should not be well taken because of the facts of this real crime. State certainly submits that whatever sentence Your Honor imposes will be based upon the law and the evidence, consideration of all the factors. But on behalf of the state of Tennessee, Olivia Hyde, family of the state, does sincerely believe this should be more than the minimum sentence. Thank you.
Well, any court that has to impose a sentence in a case like this is required to follow, as has been pointed out by both sides, the considerations and the guidelines that our state legislature has put in place to govern the sentencing in criminal cases. Those sentencing considerations are set forth in Tennessee Code Annotated 4035-103. And that provision states the following: to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Obviously, this, as has been pointed out, is a case that requires whatever sentence I impose, the minimum sentence is 15 years, and the service is 100%, meaning she's not eligible for parole at any point in time. So some of those considerations are not really relevant. Obviously, the only one this court would be inclined to consider of those factors would be that, it is in this court's opinion important not to depreciate the seriousness of the offense of aggravated assault against a minor child of 13 months. But the rest of those factors don't really apply in this case. The sentence imposed should be no greater than that deserved for the offense committed. Mr. Rabin makes an eloquent argument about the fact that our state legislature and the sentencing guidelines are that the minimum sentence is the sentence that should be imposed unless there's some basis for not doing so. But that's why we consider the aggravating and mitigating factors to help determine whether the minimum sentence is the applicable sentence. Inequalities in sentences that are unrelated to a purpose of the chapter should be avoided. The sentence the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. It goes on to talk about the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or length of the term to be imposed. So those are just some of the factors that I'm required to consider. The first thing I'm required to do then after that is to consider the range of the defendant as a criminal offender. And there's no dispute about the fact that she is a range 1 offender, which means that the range of sentence for count 1, which she was convicted of aggravated child abuse, is 15 to 25 years. And that range of sentence for count 2, which is child abuse, and that is a range of 2 to 4 years because it's a Class D felony. Then the court has to look at the mitigating and enhancing factors in order to determine whether or not the minimum sentence should apply or whether or not a greater sentence should be imposed. Before we do that, it's important to remember, and I know Mr. Rabin was not here for the trial, but this court has observed this trial from the very beginning and listened to the testimony, listened to all of the medical proof that was provided. I have reviewed that video, watched the video that was provided at court, and I think the jury did too. And I think the jury not only watched it, but they watched it very intently because they, during deliberations, came back and asked to see another portion of that video that more or less highlighted the area that of concern regarding the injury to the child's head. And as a result of that, the jury found that the defendant had committed the offense of aggravated child abuse. The factors are, of course, not the factors, but the evidence also substantiates that she had abused the child by the bruises on the child's arms, which is what the triggering effect or the first notice to the mother in this case was that there were bruises on her child's arms, and Ms. Hyde then inquired us and brought that to the attention of the daycare, and the daycare pulled the videos to start looking, and they themselves alerted law enforcement, in other words. So it's important to note that not only did the mother have concerns, but the daycare operator, the management of the daycare, thought there was great enough concern after watching the video that they alerted law enforcement. So we can minimize some of the factors that we want to, but there's no question that there was evidence that this trial, that this child was harmed. I know the defendant has argued from the beginning that she didn't really hurt this child in a severe way, and has argued that through medical testimony of her own expert witnesses that the child was not actually suffering an injury to her skull, and that there was no skull fracture that occurred. But Dr. Lakin was the testimony of the state's witness, and she testified that there was both a concussion and a probable fracture of the skull, and that it did amount to severe child abuse. And the jury considered all of that testimony of all of the expert witnesses, and they found that, in fact, the defendant had committed the aggravated child abuse. Now, looking then to the aggravated and mitigating factors that I'm required to consider, the state argues in their sentencing memorandum that the first consideration is the victim of the offense was particularly vulnerable because of age or mental disability. And as the defense points out, it is the statute we're dealing with that she was convicted of does make it a much more severe crime when it is a child below the age of 8 years. And as a result of that, the age of the child is a factor that's part of an element, if you want to call it that, of the crime for which she was convicted. I understand the state's argument that there is a basis for considering that no matter when the child is particularly unable to resist the crime, summon help, or testify at a later date. But I have to agree with Mr. Raven that I think this statute, the way it's worded currently, would exclude considering that one in a case where the child is 13 months old, and as a result of that, I do not find that victim of the offense particularly vulnerable because of age or mental disability is a factor I can consider. Clearly it is the fact, but it's not a factor that I consider as an enhancement factor when the statute has been amended to make the crime of abusing a child under the age of 8 years to be a minimum Class A felony with a minimum sentence of 15 years at 100%. So I am, out of an abundance of caution, ruling that number 4 does not apply. Number 14, that the state says the defendant abused a position of public trust or private trust, or used a professional license in a manner that significantly facilitated the commission and fulfillment of the offense. That statute does not require that the defendant have a particular license, nor that she be some professional individual that, in my opinion, at least, we have found people who were guilty, and that was an enhancement provision when they were just some family member that provided care, but they violated a position of trust. In this course of finding, there is no greater position of trust that we can put a person in than to provide care for a minor child. You know, we have a society that people have to work. It's a family that has a 2-income household almost to make ends meet. So they have minor children, they've got to have a way to provide care for those children. And when that is the case, they place those children in the care of some agency or some individual. And when you drop your child off to a child care person, there is no greater trust that you place in an individual in any way than the trust that you place in that person, that they will not only provide care for the child, but that they will not harm the child. It's one thing to negligently allow a child to be injured. It's quite another when the provider of care is the person who actually causes the injury to the child. So I do find that this is a position of trust, and that factor would factor in as an enhancement provision. I think the defense's argument that she was only in a position of authority is not relevant, nor do I think that the fact that she didn't have a license and that she was monitored really applies, because that monitoring didn't prevent her from causing the injury to this child. They had the monitoring, they had the video, and she still caused the injury. The last one is that the defendant committed the offense on the grounds of the facilities of pre-kindergarten through 12 public or private institution of learning where minors are present. I understand Mr. Raven's argument, and Mr. Raven obviously had some involvement in some of the sentencing as a participant. But the way the statute is reading right now, it doesn't distinguish. The legislature could have distinguished it and said this is only applicable to those instances where people commit violence against schools and so forth. But it is not worded that way, and so the way it is worded fits this case. The offense was committed on the grounds of the facilities of a pre-kindergarten, and that's where we are. So based on those factors, I find that both of those factors are applicable in the case. The defense has filed mitigating factors, and they argue that Sarah Jo Fusson's youthfulness at the time of the offense is a factor that the court should be considering. That actually is, I think it is number 6, the defendant, because of youth or old age, lacks substantial judgment in committing the offense. And I think it's important to read that language of that mitigating factor, because this is not a situation. She was a younger person, but she was 22 years of age, and she had attended college, had an associate's degree, if I recall correctly, already at that point, had worked in daycare operations in the past. So this is not a situation where she was barely 18 years of age and with no life experiences. So I do not find that is a factor that would apply because of her age, that she lacks substantial judgment in committing the offense. She should have known better based on her experience, if nothing else. The second is that they've cited is she lacked a sustained intent to violate the law. And that one is basically that the offense was committed, let me find the language, that she committed the offense under such unusual circumstances that it indicated there was no sustained intent to, here it is, number 11, the defendant, although guilty of a crime, committed the offense under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the criminal conduct. There is some argument to be made that this is an isolated event. But when you review that video, this child came into this room the very first time, and that was her very first day there. When you review the video, when they set this 13-month-old infant at a table, Ms. Fusson does, and then she goes over and sits and starts stroking her hair and looking at her phone. As the child starts to be unsteady at the table, she goes over, grabs her up, sits her down and forcefully in the chair, which is, in this court's opinion, and I think the jury agrees, where the bruises to this child's arms likely occurred when she grabbed her by the arms and set her down. She then went on, and the video goes on to nap time. And the nap time portion of the video shows that she put the child on a cot, and the cot had a hard plastic headpiece, and then it had a screen or a net type surface that was the sleeping area. Olivia, as a 13-month-old often do, raised up. While Ms. Fusson was trying to get other cots out and trying to get other children ready for nap time, she went back and she pushed her down and covered her up. And that repeated itself on the 8th time that she pushed this child down. And as she did so more forcefully with each of those situations. With the 8th time that she did it with such force that, in this court's opinion, and I think the jury agreed, it struck this child's head against a hard plastic surface, and the child remained motionless. Now, I've seen the letters that the family and friends have submitted, and where they make the argument this child wasn't harmed and the child moved in some way. But Dr. Lakin observed that video, observed the child's behavior and Ms. Fusson's behavior. And at that point in time, Dr. Lakin said this child was unconscious. Now, people who are unconscious may twitch or do something like that, but they don't. You don't see a 13-month-old who is raising up, active, and then suddenly stops and is completely motionless for 35 minutes only because she was forced to the mount, at least not in this court's experience. And so as a result of that, it is my opinion that there was a sustained intent to abuse this child as demonstrated from the behavior of starting with slamming the child down at the table, putting bruises on the child's arm, and then 8 times that she forced this child's head down on that. So I do not find that that factor is a mitigating factor as well. The third one is the kind of catch-all, which is the work ethic and family contribution. And there's no question, and the family has supported Ms. Fuson. They have been here for her during the trial. They have repeatedly supported her and shown, that support. And in the letters that they have submitted, and I've read them all, those letters are basically talking about what a good person she is and how she's cared for other children and she's done things for the family. Unfortunately, some of those also mimic the defendant's own position about the fact that this child wasn't really harmed and how unfair this process was and so forth. But I think that there is proof that would sustain that as a mitigating factor. So I do find that factor would be applicable in this case. So it boils down to the court to make a decision regarding the sentence. This court observed this trial. I observed the defendant's behavior during the course of the trial and her testimony from the stand during the trial. I'm not sure that I have, before today, I didn't see any indication that Ms. Fuson accepted any responsibility for this. In fact, to the contrary, she not only didn't accept responsibility for her actions, she minimized those actions. She gave excuses for those actions. She talked about how badly she was being mistreated and how unfair things were. I think it's instructive, even though this has been made an exhibit, that when the pre-sentence report was prepared, it's an opportunity for a defendant to give their version of the events. And when our probation officer went to, Ms. James went and talked to her and took her pre-sentence report and gave her an opportunity to be heard, here's what she said. It was O's first day in my classroom, and I was having issues with her sitting up in her chair at breakfast time. So I quickly yanked her back in her chair to keep her from falling to the floor. The second video is of nap time, and I was trying to get her to lay down. She wouldn't, so you can see me laying her down several times, and some parts did look rough. They say I caused bruises, but also say I caused a head fracture. I made sure she did not hit her head, and it was medically proven that she didn't have a skull fracture. But here I am in jail for it when it's not what that was. It was a wormian bone. Then during the interview on November the 13th of 2025, the defendant reported that she was not frustrated during the incident and was only trying to keep the child from falling out of her chair during feeding and trying to get the child to take a nap during nap time. On multiple occasions, the defendant made the statement, and I'm going to quote it exactly as it's written. I shouldn't effing be here. I didn't do anything. She also stated she had talked to friends, and plenty of them say they have handled their own kids that way. She stated that the victim's mother is a liar, and that the child was fine the next day, and that she brought her to the daycare and handed her to the defendant. She reported they lied in court and the child had no fracture on her skull. She stated the bruising on the child's arm just looked like a rash, and that the defendant's family is, quote, pissed because she shouldn't be there and she didn't do anything. She reported she wasn't allowed visits at the jail and that her family needs to sue the jail so she can get out of there. She also discussed how the food sucked and she really wanted a Dr. Pepper. The interview became solely focused on how this incident has affected the defendant with no concern for the child. That is the pre-sentence version of the events that Ms. Fuson gave. Now today, we saw a different side of her, and obviously if anyone who has a good lawyer is going to tell the defendant that you've got to come forward and make an allocation where you show remorse, I just don't find in this court's opinion that her expressions of remorse today are particularly sincere. I think they're motivated by good advice of counsel, as well as the fact that she realizes, having said those things, that those things can come back to bite her. Based upon all of the factors that the court has considered, my observations of the trial, the demeanor of the defendant, both at trial and during her testimony, her statements in the pre-sentence report, and all of the other factors in this court, I'm of the opinion that as to count one of this indictment, the defendant should be sentenced to 20 years in the Tennessee Department of Corrections. In count two, I find that she should be sentenced to 4 years in the Tennessee Department of Corrections, and those sentences will run concurrently with one another. And that is the judgment of the court. As to the motion for new trial, I know that there's already been a motion for new trial that has been submitted. However, the court is of the opinion that state needs an opportunity to respond to that motion or to prepare for that motion. I'm here in January, and we can set it for argument on January the
I could be heard on issues regarding,
all right. You want to be heard on the motion for new trial?
well, this is a skeleton motion.
I understand. And I'm not holding you to it. I
Right.
understand you have the right to amend it.
Right, but what I wanted to do is I wanted to deal with several things, and I was wondering if my client could be brought back in here.
Yeah, let's bring Officer Howell, if you'll bring her back in, so she needs to be here for this argument. You had filed, Mr. Raven, if we could recover this or cover this again whenever she comes out. You had filed a motion for her to be declared indigent for purposes of preparation of a transcript, and I have signed that order. I don't know if it's been, I've already signed the order, and I'll hand it to the clerk to mark that file.
So basically, that's essentially the end of it. So I got it wrong. I thought it was 25 years. It's 20. And again, the question is that a fair amount of time? I would say yes, given the circumstances. But should she be allowed to show improvement and maybe have the opportunity to get parole or something like that? I would say yes. I think it's probably fair that somebody could have that opportunity. But as you could tell from the judge, he was having absolutely none of it. I agree. You know, the defense attorney's just doing his job here, right? Like, he's trying to do the best for his client by telling her, you know, to show remorse. But there evidently wasn't any, calling the child's mother a liar and all that kind of stuff. It's a brutal situation, frankly, in every regard. And it's a sad thing. But hopefully that child will make a full physical and emotional recovery, and her family too. Yeah, it's hard to feel any kind of nice way about somebody who would do something like that. But at the same time, being real about it, I think, maybe after 10 years, it's probably reasonable, I would suggest anyway, to give somebody the opportunity to, try to be better. I don't know. Let me know what you think, though, because I'm really interested to see what your thoughts are and all of that. Anyway, folks, that was a long one. I really hope you enjoyed being here with me anyway. Sorry about the ADD moments earlier, but I just had a few things to say. But thank you so much. I want to give a massive shout out to my good friend Stephen Kane. Thank you for all your awesome comments. And again, another person who's just been so lovely reaching out when I was unwell. And there's so many of you. Too many to name. Teresa Brewer's another one that's just always been, just there. Daisy May, who else? James Liddell, Stephen, of course. Who else? God, just so many, just too many to even name. But thank you all so much. It has meant the absolute world to me to have you all at my back. Feels great, and it's good to be back. Slán